Well, as promised, let's talk to the Conservative MP Peter Bone, who was on the Leave side, of course, during the referendum. Hello, good evening.
Good evening.
The ECJ is always going to have some sort of influence, isn't it? Isn't that inevitable post-Brexit?
You couldn't possibly come up with that. You couldn't possibly say that, having read the 12-page proposal. I mean, it's quite clear, as the Prime Minister said, that our Supreme Court will be the ultimate judge of our laws. So we'll make our laws in this country, and they will be judged by our own judges with our own courts, and that's clearly what the paper says.
But there are some rules and regulations that just are affected. They are impacted by the ECJ, the European Arrest Warrant, the European Air Safety Agency, and these are things that are really fundamental to the way we live, aren't they? But
you would have said in the paper that if there is a dispute between, say, the EU and the United Kingdom, there is a dispute. We have to find a neutral way of resolving it, not English law, not European law, and that's the paper puts a number of different options down there, and the World Trade Organization disputes regime seems to me very much the sensible way to go forward on that. So it's really about this paper is about deciding disputes between the European Union and the United Kingdom, not decisions made by our Parliament, which will be determined by the Supreme Court.
OK, so when you say a neutral way of resolving things, does that mean then the creation, the establishment of new bodies, new statutes?
No, that's the point. I mean, the paper quite clearly says if you take the World Trade Organization, there is already a disputes mechanism which is used between the EU and non-EU countries, and basically what it says is, well, first of all, let's talk and see if it can be resolved. If that fails, there's something called the disputes body, which then sets up an arbitration panel, and they listen to the arguments, make a decision and a ruling, and there's also an appeal process to it. So factually, you don't have to create anything, it's already there, and that seems to me a perfectly reasonable way forward. And of course, it's already used by the EU in relation to countries that are not members of the EU. So that you don't have to create anything, it's already there.
I spoke to Lord Faulkner a little while ago, a man who knows a thing or two about the law, and he said the only way to completely, 100%, as you might say, get the ECJ out of our hair, if we want to see it in those terms, is to not have any association at all. So you don't have trade deals, you don't have the things that we actually do want that are beneficial.
Well, that's clearly wrong. I mean, that's clearly a nonsense, isn't it? There's already...
He's a QC.
Well... Our lawyer's always right, you know, and if you've got a whole series of QCs, they'll probably give you different opinions anyway. But I mean, that's just patent nonsense, isn't it? If you have a trade deal, you have a way of determining disputes, and that has to, by the nature of it, be neutral. It cannot be determined by the United Kingdom. It cannot be determined by the European Court. So you'll have a neutral way of doing it. And the document talks about 3 or 4 different ways of doing it. And I've just talked about the World Trade Organization, which seems the easiest way forward. For Lord Faulkner to say that doesn't happen, I'm afraid, is, well, to be blunt, rubbish.
Peter Bone, for now, we'll talk again, I'm sure, but for now, thank you very much indeed. Peter Bone, Conservative MP, thank you.
You didn't frankly have the balls to put country before party.